guys, welcome. Jackson Rowland here from Rowland Investment. Today I'm joined with Todd Davin, Sergio Corrales. Todd's our real estate expert in Granada,
Masaya, and also Carrasco.
Laguna de Pollo.
Absolutely.
And we're here with Sergio. He's our expert in real estate law, and we're here at his office in Managua. He has an office in Tola and in San Juan for convenience. Thanks for joining us, guys.
Thank you for inviting us.
Today we're going to be talking about what happens when we receive an offer, or how to present an offer, or
which is the goal.
Which is the closing. That's right. So let's jump into it.
Sergio, can you walk us through the typical offer process? What usually happens when someone wants to present an offer on a property?
Okay, so since this is a video for sellers,
yes,
I'm going to talk from that perspective.
Absolutely.
So actually, the seller doesn't do much until they actually receive the offer. What they need to do is look at it in detail, and I would suggest that at that moment they hire legal representation, because the offer has the terms of the deal, it has the price of the offer, how the property is going to be paid, and all the conditions related to the closing. So it is important that there is legal representation from that point on.
So sometimes in our real estate transactions, depending on who we're working with, we actually get a physical written offer, and other times it's just something that's verbal from a buyer or from another agent. How do you suggest going forward with the process to make sure that everyone is on the same page and that the contract will actually be legally binding?
Well, as a lawyer, for us, everything has to be writing.
Right.
So the recommendation would be to put all the terms in writing to make sure that both parties understand, what the offer is.
Okay, and if there is a written offer, am I understanding correctly that here in Nicaragua, it does have to be in Spanish in order to be legal?
No.
Okay.
That is a misunderstanding on the law. The law is clear. Our civil code establishes that there's only two requirements for a contract. And an offer is a contract, but from one side only. So what we need to do is we need to make sure that this offer is clear, but it could be in English. And once accepted, either accepted as received or accepted after a counter offer. So once the terms are accepted and both parties have consented to the contract is legal, regardless of what language is written.
So obviously in this offer, you're going to see something about price. You're probably going to be seeing other terms that the buyer may want, such as
closing date,
sure,
what's included in the sale. If it's a built house, a furnished house, the buyer may offer to buy the property and everything that's inside. Like I said, the closing date and then all the terms. Sometimes the offer is where the payment is not made immediately, so it's like installments. So it would include that as well.
So we use the term private sales agreement. What makes just a simple offer a private sales agreement? Is there something that you need in that document to make it an actual private sales agreement?
Yes, from the legal standpoint, an accepted offer is a contract.
Okay.
So as long as, like I said, the two parties have consented, we have a contract.
So we've received an offer as a seller. What are some of the things we've talked about? We've talked about a few of the things that are included in this PSA. What are the main aspects of the PSA in order, or how would you break down the PSA?
Okay, so if the seller likes the offer or is close enough to what they're willing to accept, I think that the first thing that we need to do is we need to make sure that both parties will be available at closing here in Nicaragua to sign it. If they're not going to be here for any reason, or they believe that they might not be here for any reason, the recommendation is to issue a power of attorney. And why do that as a first step? Because if you are issuing the power of attorney from abroad, it takes time to get it completed.
Sure.
Usually a closing happens in 30 days. So in a power of attorney issued abroad may take up to 3 weeks. So the sooner you start with that, the better.
Let's talk about the offer in terms of deposit. Now, most of the time, as we're representing sellers, we're going to want to see a deposit, an earnest money deposit, if you will. It shows that the buyer is serious. What do you typically see as a deposit amount, and who generally holds that deposit?
Okay, so a deposit is something that we as lawyers recommend to sellers because it tells the seller that this is a serious buyer. This is somebody that, this is not a frivolous offer.
Right.
Somebody that will keep you entertained for, a month and then they're just gonna go away. So we always recommend that a deposit is requested. Usually deposits are up to 10% of the purchase price of the property. That money, that 10%, is sent 5-7 days after the offer has been accepted or the private sales agreement has been signed. Once we have a deal, in 5 to 7 days, we get the deposit.
And who gets the deposit?
Okay, so the deposit is held by an escrow agent, which could be the agent, the agency, or the lawyer.
Okay. And is it generally the buyer's attorney or the seller's attorney, or that's negotiable?
It is negotiable, but it's usually the buyer's attorney.
Okay. And should that concern the seller that the buyer's attorney is holding the deposit? Because the buyer's attorney is obviously representing the buyer and working for the buyer. So should the seller be secure in the fact that that deposit is really...
As long as that is going to be available in case, at closing, or in case that the buyer backs out of the deal. Yes, if the counterpart, if the buyer's lawyer is a reputable firm, I would be fine with the buyer's lawyer holding the deposit.
And you could, as a seller, you've already got your legal counsel, so you could ask your legal counsel, is this fine for us to hold the escrow in this account, or do you know this other lawyer? Or
correct.
In terms of the purchase price, how does the closing costs sort of affect that negotiation?
The closing costs are directly tied up to the purchase price because the taxes are based on the purchase price. The lawyer's fees on both sides are based on the purchase price, and the registry fee. Everything is tied up to the price of the transaction. So it is key to understand what the purchase price is and what the costs are going to be on the seller side, because you wanna know how much it's gonna cost you, for the real estate agent or lawyer, and all the documents that need to be acquired for closing. So you know exactly how much you're gonna end up getting after the transaction has been completed.
So you clearly want to have those fees defined in the offer so everyone knows what's going to happen.
Yes.
And I think that in different market areas and historically, different things have happened with the transfer tax. Can we talk a little bit about transfer tax and the seller, because my understanding is that it's legally the seller's responsibility to pay the transfer taxes. However, we have come to a point where a lot of times the buyer is paying it. Can you address that issue?
Yes, so the so-called transfer tax, it's actually a capital gain. So as you said, it is the seller's responsibility to pay. What happens is in the process of recording a title in Nicaragua, you don't end up getting the bill for the taxes until weeks after closing. I'm going to say sometimes even months after closing. If you're representing a buyer, you don't want to be chasing after the seller. You have to pay this taxes. So what usually happens is that that amount is assumed by the buyer. And this is why any reputable attorney will, as soon as they get a contract or an accepted offer, they will prepare a closing estimate and they will establish the amounts that each party has to pay. So in the case of the sellers know that they're going to usually pay the real estate commission, then their lawyer, and the documents that need to be prepared for closing. And on the side of the buyers end up, they pay the due diligence, they pay the escrow fee, they pay their attorney, and the transfer tax. And the rest of registry fees, like the fee that's paid to the public registrar for recording the title.
As a seller, what are some of those documents for closing that I'm going to need to pay for? Because typically everyone will say, oh, the buyer pays all the legal and taxes and the seller just pays the commission. But there's a few documents that the seller does need to get, and they usually cost a little bit. What are those ones that we can usually expect?
Sure. So in all transactions, the seller always has to pay a survey. So a surveyor has to be hired, and they need to go out to the property and they need to prepare a survey that has to be filed before a government agency called the cadastral office. And there's a fee for paying that. There's a fee that the surveyor will charge. There's also a free of lien certificate that's issued by the government, by the registry. There's also a fee to pay for whoever's doing that for you and for actually getting the document from the government. There's the solvencia, which is a very small fee, 100 fords, and that is if you are up to date with your property taxes. And then, depending on what transaction, where the property is located, etc., there could be other documents that need to be provided. For example, an HOA solvency to prove that the property owes no HOA fees to the development. There could be other documents like the no objection certificate. That's also a document that there's a fee the lawyers would charge for getting that or processing that for you. And then there could be other documents, if a car is included, then the title of the vehicle and things of that sort.
If the property is in a business, you also need to produce other documents for the business.
All the documents for the business.
Yeah.
If you're buying a property that's in a company, you're buying the shares of the company instead of buying the property, then you're acquiring the shares, and there are all the documents that need to be prepared having to do with that company.
Yeah, and that's from the seller, because they need to show all those documents.
And at this point, I've had transactions where that has become a process in and of itself, because people have just have the property in the corporation and the corporation has since been frozen or inactive. So it's a process that can be quite lengthy and expensive to get that corporation active again in order to actually transfer the ownership.
And that is key to tell your lawyer. If you're the seller, it's key to tell your lawyer that I'm selling shares of the company, and this is how the company is right now. It's up. Everything is up to date. Great. If it's not up to date, well, where are you at the moment? So we can calculate how much time we need to get everything in order before closing.
And if a company is frozen, is inactive, how long does that generally take to get that company active again in order to be able to transfer the shares?
It depends on so many factors that it's difficult to say, but I'm going to say that in average, it's about between 1 and 2 months.
Okay.
And that's to sell the shares or even to sell the property out of that company. Yes. Sometimes people want to transfer the asset out of the company and not sell the shares. It's the same thing. You need to update the company. It needs to be sold before you can do either of that.
Yes, and the agent and the lawyer you choose are very important, because when you have a buyer that's interested in your property, usually they want the property as soon as possible. And 30 days is an acceptable term, but sometimes it's going to take more time. So you need to have somebody on your side that will know how to explain this, so it's not a downer to the buyer.
Because a proficient lawyer can get the standard documents, the Libertad Grobman, Solvencia, property history, that all can be had within 2 or 3 weeks.
Correct. Yes.
So 30-day escrow is very possible in a uncomplicated, normal situation.
Correct. Well, I think that we need to talk about the escrow agent. The escrow agent has to be someone that is, number one, reputable and responsible, because they need to make sure, they need to confirm to the seller that the money has been received and that the money is available and that it will be distributed as soon as the closing has been completed.
Now, I know that sometimes the escrow money is held in the United States and sometimes it's held in Nicaragua. Are those both legal options?
Yes, absolutely.
Okay.
So you've given the deposit, the money's being held in escrow, either with the agent, escrow company, everyone's agreed to the terms, we've done the due diligence, we've got all the paperwork, we're ready for closing. What's the process leading up to closing from the seller's point of view?
So from the seller himself or herself, there's not much to do if they hire a good reputable attorney, because they will take care of everything. Which is basically gathering all these documents, and usually the actual closing documents, the transfer of title deed, is prepared by the buyer's attorney. The seller's attorney has to be quick in making sure that they receive the draft of the document in time, so they can have enough time to review that everything is fine. And then it's basically a waiting. It's waiting. Once you have all the documents that you need for closing, it's just basically waiting for the confirmation that all the funds for the purchase are in the escrow account, and that as soon as we approach the closing date, be ready to sign.
And that's the same escrow account, or you can have different escrow accounts for the deposit and the actual funds coming in?
It's one single
one escrow account.
Let's talk a little bit about if escrow is closing but the buyer is not paying in full. So there's going to be some type of payment schedule. How is that defined in the transfer paperwork? Should the buyer expect that, or should the seller expect that title is being transferred or held? What's the legality of all of that?
Okay, so Nicaraguan law gives you 2 options. So one option is to transfer title to the buyer with a mortgage, and if that is what the parties decide to do, the seller's attorney has to make sure that to take over the recording process, because they need to register that mortgage. The alternative is to only sign a promise of sale. In a promise of sale, you're not actually transferring title. You're only saying that you will eventually, when these conditions are met, transfer title to the seller. In practicity, they're the same. The buyer will take over the property at closing, but they won't get title until the property has been fully paid.
Okay.
And in the case of mortgage, when it's fully paid, the seller has to sign a document canceling the mortgage, so the property is free.
So either way, the seller has some protection in terms of, or some recourse if the buyer does not pay.
Correct. In both cases, the seller is protected, that if there is a default on the side of the buyer, they can get the property back.
And is that a difficult process to get the property back?
That's where hiring a good, reputable, experienced attorney will help a lot, because then we can draft the documents in such a way that we will make it easier to get the property back in case of a default.
whether it's the mortgage or the promise of sale, those documents are both registered with the state in the registry.
That's correct.
The escrow account and the escrow agent, why is it important to have a reputable company or agent behind this part of the deal?
Because first, they're going to be holding all the funds for the closing. And you need to know as a seller that as soon as you sign transfer title to the buyer, you will get the funds transferred to you immediately. And so it is very important to choose somebody that is responsible enough and reputable enough to hold the funds.
Let's talk a minute about the actual closing and how that all works with signing, and then when the seller can expect the money and when the buyer can expect to get the property possession.
Okay, so usually the possession is transferred from the seller to the buyer at closing. So as soon as both parties have signed, the seller signs transferring title and the buyer signs accepting title. Immediately the keys are handed over and it's the buyer's property from that moment on.
Should the seller expect that the money is already in their account before they get possession, or?
So the work of the escrow agent is to hold the funds until they've been notified that the transfer has been completed. So once that has happened, the escrow agent will immediately start the process of transferring the funds to the seller. It depends on many factors: which country the money is being sent to, which bank the money is being sent to. If it's a large bank like Bank of America or Citibank, it's usually quickly. It happens the same day or the day after. If we have to use an intermediary bank, there is no connection between the Nicaraguan local bank and the Canadian bank seller. An intermediary bank has to be used. So the money has to go from the Nicaraguan bank to the intermediary bank in the States and then to the Canadian bank or the local American bank. And that usually takes anywhere from 3 to 4 days.
And just worst case scenario, something happened and the funds never showed up. Is there some recourse that the seller has to take back the property?
Look, we have done in the 8.5 years that we have been in business, we have done, I'm going to say, over 1,000 wire transfers. We've never had an issue, and we have never heard of any issues with other escalators. In that very hypothetical, unlikely case, then yes, the seller, the Nicaraguan Supreme Court has said in many rulings that until full payment of the price has been received by the seller, the transfer hasn't been completed.
Okay.
What about exchange rates and like who's in charge of making sure that if they're transferring from international banks, if the exchange rate's off, and is it on the seller, the buyer's attorney, like who calculates all that?
So in our case, we work with US currency. So we receive dollars and we send dollars. So there's no problem, there's no issue of rate of exchange there. Now, if the money is going to a different currency, like euros or Canadian dollars, that has to do with the seller's bank. Is whatever they charge for transferring the funds from US dollars to the currency, euros or Canadian dollars. One thing that it's important to know is that there is a fee charged by the sending bank. There's another fee charged by the receiving bank, and both of them are assumed by the seller.
I've received an offer. My lawyers or my brokers, my agents have sent me an offer. I'm happy. I've looked it over. It's not quite what I want. How do I go about presenting a counteroffer or changing the terms?
So if the offer is not exactly what you want, you can always counteroffer. You can always tell the potential buyer, I'm willing to accept this offer if this happens. It could be that you up the price on the offer a little bit. It could be that you shorten the installments of payments. It could be that you want to exclude something from the sale, like a piece of art, for example, that has sentimental value and you want to take that with you. Your agent should be able to assist you in preparing a counteroffer, which is basically saying, I accept this offer, but with this condition. Then it's signed and it's sent to the potential buyer, and the potential buyer usually responds in 2 to 3 days. You can include, if you want, a term of expiration of the capital. And from that moment on, it's on the potential buyer side if they are willing to accept that counter.
Let's talk a little bit about things that are included in the sale, and then additional items that you may want included that are not necessarily part of the deal. Obviously, I'm sure we want to outline everything as much as we can, but do you suggest taking a full inventory before an offer, or at some point in the process, how do you deal with an inventory of items that the buyer's expecting or that the seller is going to be given? So
the best way to go is to do this full inventory, because then this is something that can be checked at closing to make sure that everything is included, and you won't have surprises like, wasn't a painting on that wall? Right. Things of that sort. You can have everything. If you have everything on an inventory, then that's what it is. But sometimes it's the other way around. Sometimes this says everything is included, but these items. And it could be, like I said, a piece of art, or it could be some motorcycle, an ATV, some things of that sort.
But it's good to do that inventory before the offer's done or with the offer. It's not something that comes after the offer.
Well, it could be either way, but I would say that you don't do the work of the inventory until you have an accepted offer.
Okay.
Are there items that are inherently part of the deal? Like things that are attached to the wall? Is there a law behind that it includes them, or is everything negotiable?
So according to Nicaraguan law, the movable property is the land and all the buildings.
Air conditioners, ceiling fans.
Usually air conditioners are included. Everything else besides that is a fixture, and it's not included. The custom is that appliances are included in the sale, but according to the law, it isn't. So it has to be included on the list if the buyer wants it.
Sure, it makes it even more important to define everything clearly from the beginning.
100%.
The more detail, the better. In the deals that I've known, it's the more detail, the better.
For both parties. Then everyone knows what's going on.
Yes, because the conflict may come from
either side. Sure. When seller's not going to be in country for the closing, so they can give a power of attorney. Who generally do they give a power of attorney to? Who's the person who's going to be signing for them?
So usually somebody on their team. So it could be the agent, it could be their lawyer. Usually it's the lawyer, or somebody working in the lawyer's office. You just need to make sure that that person will be at closing and that they will follow instructions of the sale.
And generally, it's a very limited power of attorney, correct? It only allows that person to sign to close the transaction. They can't do anything else with that power of attorney.
Literally is what you said. It's specifically for signing a deed transferring title to Mr. X.
Is there any situations where the POA doesn't work? For example, with lease contracts with municipality?
Yes. Yes. So some municipalities require that the actual leaseholder is the one who signs. So in that case, a reputable lawyer will know, and they will tell you that you have to be present. So you have to make sure that is understood. And I'm talking about the closing date, because you need to make sure that you will be there. So you know, if you can't be outside the States on a specific date, well, you shouldn't put that as a closing date.
But pretty much for everything else, if it's signing a business, an SA, yes, selling shares, any kind of title of land, it's fine to use a POA.
Absolutely.
Can you walk us through if we're selling a house as a seller and the buyer is concerned about the building, wants to get a building inspector in, how does it work with third-party building inspectors and checking all the structural details of the sale?
So that's part of the due diligence process on the buyer side. They're the ones who have to hire somebody to come and inspect the property to make sure that, you know, it has no issues with the construction. They usually come within 2 weeks, and a week after that they have a report. Usually it is requested by sellers for the buyer to share that report. And sometimes, usually, you know, structures are fine, so the reports say that everything is fine. Sometimes they will have some indications like the roof has to be changed in 10 years, things of that sort. And sometimes buyers use that to renegotiate the price, because there is a chance of renegotiating the price based on the deal. And that could be because of physical things, like what we just mentioned, or it could be because of legal things. Like there is an old mortgage that's registered that really has no value, and somebody has to go and pay for it to be canceled. So sometimes it's used by buyers to try to renegotiate the price, and it's up to the seller to actually do renegotiate the price or not.
And historically, home inspections were not really done that much in transactions here.
I would say less than 5%.
Okay, so and is that something then that that really needs to be defined in the offer as well? That there is an inspection and it's a certain period, and then after that period is over, if the buyer hasn't done the inspection, then they're waiving it, or something to that effect?
Yes. That's what we recommend, that if the buyer wants to have an inspection made, that there is a term given for that inspection, and that there's a term given for the report. Because there has to be a date during the process in which you know that you're closing on the property, for sure. And that's the best way to guarantee that.
We've gone through everything. The money's been put into escrow. We've agreed upon a date for the final signing. What documents does my lawyer, as a seller, need to bring to the final closing?
So the seller's lawyer has to bring all the documents that we already discussed. So Valencia, pre-agreement certificate, HOA, solvency, survey, approved survey, the original title of the property, and copies of the IDs of the seller. That's usually what's included. And this is all the work of your seller's lawyer. They do everything for you. You show up just to sign. You know, before signing, both lawyers will communicate and will hand over the documents. The documents will be reviewed by a buyer's attorney. And if it's a good attorney that's working for you as a seller, the copies of the documents have already been sent to the buyer's attorney. So they're just confirming that what they're receiving is a copy of what they already saw.
Question on original title. What happens if the seller cannot find the original title?
So there are two options. One is to request a segundo testimonio, which is the second certified copy of the title. You do that by contacting the notary of record when you purchase the property and asking them to issue a second certified copy. then you must hand that over to your attorney. The attorney has to go to the public registry and get the registration information on that side.
Okay.
So that's one option, and then the other option is to get a certificate from the public registry, which work at the time, according to the law.
Both of those sound like they can take some time.
The latter one takes less than a week.
Okay.
And all the one is all about contacting the notary. If it's a notary if it's a notary that's available, they will be happy to, get a few dollars to issue that second document. The problem is when you don't find that notary, or if the notary has passed away. If that's the case, then you have to locate where this protocol. And sometimes it is at the public registry, sometimes a family member, if they're lawyers, they would have.
So again, as a seller, you should be working with your attorney from the beginning, making sure that you have all of your documents before you ever go down the road of selling.
100%.
Okay, so we've all signed, everyone's happy, lawyers are happy, everyone shakes hands, the money gets released to the seller's bank account, hopefully. Are there any issues with receiving money, or what do I need to take to my bank to show them that I'm gonna receive all this money? Like, what are the documents that they need to see?
So your lawyer should have done their homework and should have first made sure that they have copies of the origin of the funds, to make sure that the funds don't come from money laundering or things like that. And they will send you, along with the wire, they will send you an email with the copy of the title of the property you just sold, because you need to show that to your bank. So your bank doesn't get spooked that they're suddenly receiving $400,000 in your account. One thing that I should also mention is that the escrow agent will distribute all the funds. That means that you will get what the closing estimate indicates that you will end up getting. So they will distribute to the agents and to the lawyer and for expenses, and you get the net amount of money that you get.
How does it work with after the closing? I've got the keys to the house or the property. Do I need to go there with the buyers? Do I need to go there and give it to the buyer, hand it over, or is that my broker that does that? Who typically does the walkthrough with the inventory with a new buyer?
So usually in the inventories are done prior to closing. The review of the inventory is done prior to closing. So after closing, you hand over the keys and that's it. Sometimes the checking of the inventory is done afterwards, and that it's up to you if you wanna be there. That's the job of your agent.
So, and does the seller have any responsibility or liability after the close of escrow? So we signed, handed over the keys today, midnight tonight, a pipe bursts in the house and the buyer's already in possession. Is the seller responsible for that?
Unless it's something that the seller knew about and did not proceed to resolve the matter. No. As soon as the property has been, actually sometimes even before closing, the buyer accepts the responsibility of everything that's having to do with the property. Like in the case, for example, of payment in installments, the seller will take over the property and still don't have title to the property. But as soon as they get into the property, everything is their responsibility, or at least that is our recommendation. The contract says exactly that.
So with an installment agreement or a mortgage, so to speak, that the seller is carrying that, the buyer is assuming responsibility for all of the taxes, all of the maintenance, everything.
Everything.
is it recommended for, if I'm the seller and I'm handing over the house, typically you would make the buyer get insurance for that house if it's a promise of sale. So it's still in
Oh, sorry.
Yeah.
Yes, if it's a promise of sale, yes, there are requirements that that you need to make sure that the buyer accepts. Like, for example, keeping insurance on the property, making sure that all property payments are being made, that all utilities are paid every month.
They can't do any improvements on the house unless it's with your approval.
So we've used the term due diligence and due diligence period. Can you elaborate on that a little bit more and what that actually means?
The due diligence is both physically, or it could be both physically and legally. On the physical part is the process of verification that the structure doesn't have any issues. And on the legal side is the process of verifying that the property is as represented by the seller. Meaning that it's 3 obedience, that it's a good and marketable title, that there are no encumbrances on the property, no mortgages, that the property taxes are paid up to date, etc. So that's the due diligence. It's all done by the buyer's team, and it usually takes from 10 to 15 days to be completed.
So if the seller is able to prove all of that, to provide all of the due diligence paperwork and it's acceptable to the buyer's attorney, then at that point, can the seller assume that the deal is going to close? And if the deal doesn't close, the buyer would forfeit their deposit? Or what happens if the buyer just decides no, for no reason?
So the contract would probably establish that as soon as that has been completed, the due diligence has been completed and the potential buyer has received positive report from both their attorney and their structural engineer. At that moment, the deposit becomes non-refundable because everything is as represented, and for any reason the closing is not other than the seller suing. For any reason the closing doesn't happen, usually the contract established that the seller keeps the deposit and obviously has to share something with the agent because it's not the agent's fault that the property is not closing, but they keep the deposit.
Well, thank you guys for this final episode of the Seller's Guide. We hope everyone at home enjoyed all the informative information.
Our series.
If there was any questions or any other further information you'd like, just comment in the section below or email us. I'm sure Sergio, Todd would be happy to reach out and answer anything else. Thanks a lot.
You're welcome.
See you for the next series, the Buyers series. Keep a lookout for it.